thank our sponsors, and if you get a chance to meet them in person, thank them as well. We have a wonderful panel today to talk about kind of called Ask an Attorney, and obviously the discussion is going to be all about business. Our moderator today is Ryan Maloney, who is also the counsel for the chamber, so we know him on another front, but he is a phenomenal person. He works for Foley and Lardner in the business litigation and dispute resolution, as well as construction. At this time, I'd like to introduce Ryan to come up and introduce our wonderful panel today. Thank you so much.
Good morning, everybody. Glad all of you could make it. Got a nice opportunity here to ask the lawyer to get some free answers instead of how we usually do it, just for charge. I'd like to just have if each of you could just take a moment and introduce yourself and tell a little bit about your practice, and we can get into the questions that folks may have. Mark, you want to start?
Sure. Hi, thank you for having me. My name is Mark Addington. My practice focuses on employment law and all things employer related. So I do a lot of work with wage and hour issues, with discrimination related issues, with internal investigations. All that is HR, if you will, in the business. I also do a lot of issues relating to contracts. A lot of smaller businesses engage in contracts for setting up, relationships with employments or independent contractors, and I deal with those types of things rather frequently as well.
Hi, I'm HICKMAN, and I work with Grady in Orange Park. We do various areas of law, but recently we've been focusing our practice on doing estate planning, elder law, which is helping people qualify for Medicaid applications for long-term care in a skilled nursing facility, and also on probate and trust administration. We also do quite a bit in business law.
Good morning. I'm Dave King. I'm an attorney here in Orange Park. My practice is primarily transaction-based. We deal with purchases and sales of businesses, leases, contracts, franchising. I also do some estate planning, and when I have hard questions, I call Allison.
I call him when I have hard questions.
Good morning, I'm Charles McBurney. I actually have two jobs, and so I guess I'm here wearing two different hats. The first hat is I'm a business lawyer. I've had my own firm for the last 10 years, and before that I was with a little boutique law firm, Shedon Health Party. Do a business law, mostly commercial litigation, commercial collections, and business bankruptcy, mostly a creditor's rights practice. And that's the job that I try to do that hopefully helps me earn an income. A job that doesn't pay that much in terms of income, but one which I do enjoy. I'm a state representative from Jacksonville. I represent the southeastern part of Jacksonville. I have been in the legislature since 2007. I have the longest continuous service of anyone in the Florida House. And this year, I'm going to be chairman of judiciary, so we'll be dealing with many of the cutting-edge legal issues out there.
Well, as you can see, we've got a great experienced panel here. I thought maybe I'd start out with kind of a start-out question, and this is if you folks have follow-up questions or your own questions that you might want to ask, feel free to just raise a hand and we'll facilitate that. I think one of the things that I'd like each of you to kind of briefly talk about, and whoever wants to start can start, but in your practice, what do you see as kind of the biggest issue coming up in the next couple of years or next year for facing small businesses? And if whoever wants to kind of kick it off would be great.
Okay, well, I've got one. The Fair Labor Standards Act of 1938 basically dealt with all your wage and hour, how you pay people. And that particular law has really only been changed once in terms of how somebody is determined to be exempt from overtime or not, and that was back in 2004. President Obama year asked for all of those regulations to be changed again. And that's going to be a huge issue for business, figuring out whether or not your employees qualify for the exemption of overtime. General presumption is that employees are entitled to overtime unless they meet a very narrow exemption. So now all those exemptions are changing, and that's going to have a big impact when that comes through. So those are rules that are down the road. When I say down the road, I'm thinking within this year, that I think will start to be more and more of an issue for small businesses to understand. And wage and hour is an area in which small businesses frequently mess up. We believe the Department of Labor, 70% of the businesses out there have issues with regards to paying people properly. So I see that as a ongoing issue that will continue to be more complicated.
Just as a follow-up on that, Mark, other than coming to talk to you, what can folks do to kind of keep abreast with those issues and be aware of changes that are coming down the pipe?
Well, most of it, I think, is just finding a good resource, finding a good place where you can get information. A lot of them are available online. You can monitor the Department of Labor even, and they post things regarding tools to help employers to stay compliant. But the wage and hour is already difficult to comply with. And so if you don't, or you haven't had any sort of plan for looking at trying to stay compliant, look for online tools. I'll be happy to provide online tools for you in terms of resources. If you send me an email and say this is important to me, I'd like to see those. Yes, sir.
And just one more follow-up, Mark. Sorry. How big of a company do you have to be for these kind of laws to apply to Fair Labor Standards?
Small, tiny. Really, the parameters of qualifying as an employer under the Fair Labor Standards Act is very small. There are some arguments that some businesses are not qualifying because they don't meet a certain sales threshold. We call it enterprise. But the vast majority of small businesses are covered. And since you engage in interstate commerce as well, that's part of the test. And if you're a business that takes credit cards, you engage in interstate commerce. So it's written very broadly, and generally businesses are construed to be, for that to apply, they have to really fight to say that for some reason I'm not. If you had a business that did not take credit cards, had one employee, and generally didn't do anything to trade outside of the state, you may be able to make an argument that's a very narrow argument. So
it sounds like something that everybody needs to be aware of and pay attention to.
yes, sir.
Dave?
Mark, if you don't mind another follow-up question. Earlier you mentioned the overtime exemption and that there's new legislation coming. Is that new legislation in response to perceived abuses of this overtime exemption?
Let me clarify, because maybe I said it wrong. In 2004, the Department of Labor looked at Section 541, which defines the regulation that defines these exemptions. There's a lot of political influence in terms of what will happen if we narrow or if we expand these, because it'll affect the degree to which the American worker gets overtime. But all of this, from the Department of Labor's perspective, at least in my view, is responsive to the perception by the administration that business abuses people by misclassifying them. As an example, in the last 5 or 6 years, the Department of Labor has added literally hundreds of investigators. And so there's substantially more audits happening for businesses out there of all sizes. So, yeah, to answer your question, a little more complicated. I do think that the Department of Labor looks at businesses and feels like not only are they misclassifying, businesses frequently misclassifying, but that frequently is a revenue stream because, for employees, in some cases, if they're misclassified, for instance, as an independent contractor, as opposed to an employee, then the employer isn't paying taxes on the independent contractor. So there's a lot of thought about how workers are classified, whether it be that they are exempt from overtime improperly or they're classified improperly as independent contractors.
Thank you, Mark.
Does anybody else want to weigh in on what they think are the sort of big legal issues coming down the pipe for small business?
So essentially, Mark, you're saying that the revisions that Obama's putting in is more employee oriented then?
I would have a hard time saying anything that he hasn't done is more employee oriented. There's a lot of changes going on in a number of administrative agencies on the federal level. The National Labor Relations Board is an example of that. They're very, very aggressively employee friendly. So, you know, I'm not trying to place value on that, but I do think small businesses need to be aware of changes that are happening with these agencies that are going to create some liability for their businesses, and that's really the focus of what
So
I'm
it's
focusing on.
going to, it'll probably make harder for small businesses to survive?
Well, I'll give you an example. The NLRB, like 3 days ago, essentially held in a case that employee email systems can be used for union organizing. That has never been the case before, and all the precedents basically is that an employer's computer systems belong to the employer and they can monitor, regulate, and determine what types of communications are on their equipment. So this is a recent decision that can have some very serious impact. I expect it to be appealed. I expect it to go into the federal courts, and hopefully it won't be something that will have a big significant impact. But it's just illustrative of an administrative agency that's taking some very interesting, different steps that can create liability for small business.
And let's follow up on that. Can you talk briefly about what are the liabilities, for instance, if an employer's not paying proper overtime or those types of things? What can happen?
If I had an employee who was feeling like they were improperly paid, and first of all, the duty to keep all of the records is the employer's and the employer's alone, okay? So if an employer isn't doing a good job of keeping track of the payroll records, for instance, that can create tremendous liability, because then where does the court have to go? The word of the employee, and that's the only place, because then you get your burden. Now, what's your liability? What is the damages to that? Let's say I owed, it was all calculated to determine that I owed this employee $3,000 for a year. And if I was found to be liable as the employer, I would owe that employee $3,000 for that year, but if you can go back as far as 2 years, and 3 years if my violation is considered willful. So most of the time when you're negotiating these things, you have a plaintiff's attorney fighting hard for 3 years of liability. You're trying to limit your liability to at least 2. But even 2, that's $6,000. But there's another type of damages called liquidated damages, which is in a like amount. So that $6,000 becomes $12,000. And then not only do you have to pay your attorney to defend you, but according to the statute, and there's a strong presumption, the employer pays the plaintiff's attorney as well. And that is usually a lot more than the $12,000 we're fighting over, or actually $6,000 we're fighting over. So what became $6,000 in potential liability was doubled, and then you have 2 sets of attorney's firms that you have to pay as the employer as well. So you could easily pay $30,000, $40,000 for a claim that could have been 6 if you figured it would
Sounds like
solve.
something you really want to pay attention to on the front end and avoid these kinds of claims.
Yeah, exactly.
Dave?
You were looking for biggest legal issues. How about a minor legal issue, but one that has impacted a lot of people? Charles and I were just talking about this earlier. There are now at least 6 firms here in Florida, most of them operate out of Tallahassee, that are running scams where they are sending to businesses some type of a form that they make look like a very official document. It comes in a very official looking envelope, suggesting that you need to fill this out and send it back with X dollars. Every one of those is a scam. It's not something that's necessary, but they make it look and sound like it's necessary. I have been amazed at how many of my very bright clients got the form, looked at it briefly, signed it, wrote a check, and sent it in, and they get nothing for what they've done. Of course, the sad thing is, if you would have read it closely, and, when people in a hurry, I can't really blame them for, not reading it thoroughly, but somewhere buried on there, in very tiny print, it says, this is not from a governmental agency. This is not an official document, even though up in the upper left-hand corner, it's stamped with official document. The really sad one is the one that confuses people into thinking that this is now their corporate annual registration that everybody does every year in January, and they think they've now complied with that and sent the money in, only to get the nasty letter from the Florida Secretary of State later in May saying, you did not register for this year. You now owe the normal $150 or so plus a $400 penalty. And I've had a lot of folks that thought, I thought I sent that in. I can prove it. I've got my canceled check. And they bring it to me and I go, you got suckers. So, in fact, the one form looks a whole lot like the computer screen when you're actually doing the normal registration. In fact, it really looks like the old way that we used to do it when you could do it manually and send it in by U.S. mail. It's incredible the level that they've gone to mislead people. And seriously, I've had some very bright clients that have gotten suckered in and fell for this. And it's a complete waste of money. And like I say, I believe there are now at least 6 firms doing this. So warn your friends and please don't.
I've seen those too. I've seen them with perforated edges like they came from the Department of Revenue, and they looked just like it was coming from the agency. So.
Yeah.
We've had a lot of clients talk to that as well.
And so as a takeaway, I guess, read everything you get that has your money very carefully, and if you have any questions, maybe call the government agency itself, or talk to your attorney.
Or bring it by. I've had a lot of folks just walk in my front door and say, Dave, what's this?
Yeah.
What's this all about? I go,
I guess the best thing is to just be skeptical. These scams statewide are getting more and more sophisticated every year. It's not just the Nigerian prince thing you get on the email. They're very sophisticated. It's very difficult to stop. We talked about doing something reporting to the Attorney General's office, see if they can investigate this. In some cases, kind of like whack-a-mole. You get one down, there's going to be another. You've got to play defensively.
Yeah, I'll tell you, even as an attorney, about once a month I'll get an email saying, can you help represent me on this case? And you can just sort of tell by the email that it's a scam. If you click on the link, you're in trouble. So I think that the idea is everybody should be careful. Yes.
Hi, good morning, and thank you for coming here today and taking your time. I have questions for all of you. And thank you for bringing that up, because we also have a lot of clients that either we catch them before they write the check or it's afterwards, and they're like, oh my goodness, I can't believe I fell for that. So thanks for bringing that up. And I have a question for Mark, going back to the employment laws. Payroll is a sore subject for business owners, and there's a lot of confusion on classification of workers, and I wonder if you could elaborate a little bit on what makes a worker a exempt salaried employee versus an hourly employee, and then also there's a lot of confusion about contractor versus employee. And the DOL is cracking down on the exempt or non-exempt, and the IRS is cracking down on employee versus contractor. And so what can a worker do if they think that they're misclassified as an employee versus a contractor, especially if they're a contractor, which is most often the case, but they think that they should be an employee and they're already in that relationship? And then what is the difference between the salary versus the hourly?
Great questions. I want to be cognizant of not taking everyone's time on this or turning it into the Mark show, but I do think that those are important issues for businesses. Kind of a quick primer. All employees are entitled to overtime, period, unless you qualify for narrow exemptions, okay? If you're paid by a salary, does that mean you're not having to pay overtime? No. Salary is just one part of the test, okay? So you cannot have an hourly person exempt from overtime. But if you want to take the exemption, you have to be paid on a salary basis. You have to make over $455 a week in a salary to get the exemption, okay? So there's two parts to the test. One side is salary basis, and the other side is job duties. And what needs to happen is you need to do an analysis of not the title, but the specific duties that the worker, the employee does, and make sure that they qualify under one of the exemptions. Section 541 has a list of probably about 7 or 8 different types of exemptions. 3 are the prominent ones. You have your executive exemption, you have your administrative exemption, you have your professional exemption. Most of the challenges are administrative exemptions, but there's a significant amount to deal with whether somebody is truly a manager. I'll give you a case in point. There's tons of litigation and just a long history for a company you all know called Starbucks, right? Those managers, how different are they from a barista? Technically, they do, when they actually do the job duties, much of what they do is very similar to every other employee. They just are also in charge of inventory. If you want to call them an executive, they have to have authority to hire and fire. They have to be part of managing at least 2 people. So many of those managers don't have that authority because they give that to district managers, and those guys just run the store as the sort of team lead, but we're going to call you a manager. That's why they're running into a lot of problems and have historically with not meeting the exemption because of the actual duties. So the duties that your employees do are a challenge. Now, I have a client recently that had huge wage and hour issues to the tune of, we ended up settling for over $200,000. And he was a small business, and he was growing. And one of the things he wanted to do was he wanted to go to different cities and open branches, but he was going to open a branch with one branch manager that had to grow the business to a certain volume to get employees to work for him. And he wanted to figure a way to compensate them well as executives, but he couldn't call them executives and get an exemption from overtime. So there's lots of times when small businesses are growing that you really need to think through whether or not the employee worker really qualifies for the exemption or not. And so we had to design a whole different compensation program. So besides this, the classification issue, which you're absolutely right is a huge issue, and businesses struggle with it. Also things like deductions, whether or not you can take deductions from employees or salaried people. And so when the economy went south 7, 8 years ago, a lot of employers, a lot of small businesses started doing things like cutting employees' hours back, because we didn't want to fire anybody, so we cut hours back to try to survive. Well, if you take a salaried exempt employee and you say you got to work 30 instead of 40 hours now, does that mean you can cut their salary by 20-25%? The answer is no. Okay, that deduction is not appropriate. So, things like that are important, because a salary basis and the exempt as an executive essentially means you're required to work whatever it takes to get the job done, whether it be 60 hours or 30 hours. So there's all sorts of variables there that need to be considered. The second part of your question dealt with independent contractors. And you're right, the IRS has really aggressively been going after employers in this regard. With independent contractors, the IRS has a 20-part test. Historically, about 2005, that changed a little bit, and really it was the same test, but we looked at areas of control. Behavior, controlled behavior is the key, and then whether or not the employer was supplying the equipment for the worker, or whether the worker was supplying their own equipment. In the courts, we developed something called the economics realities test, which basically meant as an economic reality, this person was truly an employee. Where small businesses mess that up a lot of times is that they have employees that are doing exactly the same things as independent contractors. And how do you justify one as an employee and one as an independent contractor when they're doing the same thing if you're managing in the same way? So the thing to remember about independent contractors is a couple of them. One is, you gotta be very careful to manage the result and not the path to get to the result. In other words, I contract with you to make 10 widgets and deliver it to me at the end of the month. How you do that, scheduling-wise, equipment-wise, is your deal. All I'm managing is that result. If I train you how to make the widget, if I give you the tools to make the widget, if I tell you to be here between 8 and 5 to make the widget, I'm not treating you like an independent contractor, and I will probably fail all of the tests that say so. So control is a big part of that. Is that helpful, or did I address all of what you asked?
Yes, I was just wondering if the employee, if the worker is actually an employee, but the employer classifies them as an independent contractor, because I have to tell clients all the time, it's not your decision as to
Right.
whether they're a contractor or not.
Right.
It's the IRS rules that govern that. So if they are misclassified and they are being treated as a contractor, but they really should be an employee, what is the employee's options to remedy that?
Well, generally, if they're misclassified, this is how it usually arises. What's the name of the gentleman to your right there? What's your name, sir?
Andrew.
Andrew. If Andrew were working for you as an independent contractor and got hurt on the job and filed a claim for workers' comp because he doesn't know better and you've been scheduling him and he's hurt on the job and he uses on the job, and you've been paying him as an independent contractor, now the agencies are communicating much differently than they did in the past. So what will happen is that he'll put in that claim for a workers' comp injury, you'll get a notice, but the IRS will know you've been paying him under a 1099 as an independent contractor. So that's a huge flag that either he's been misclassified and revenue that should go to the government based upon unemployment benefits or workers' compensation benefits haven't been paid by your business. So you'll probably receive an audit. And so that's a lot of how this thing happens. So in terms of liability, if he agreed to it, generally you don't have workers that say, I was misclassified. You usually have the government agencies saying, as a result of your classification, we've gotten a red flag somewhere and we're coming after you. So most of the time the small business is dealing with the classification issue, not with regards to a worker, but with regards to an enforcement agency. Does that make sense?
Any other questions on that area? Another question sort of for the group is, in your practice, and maybe I'll just throw this to you first, David, what do you see as the most sort of common mistake that you see clients making that they could avoid on the front end? And what would you suggest as ways to try to avoid?
This may sound a little self-serving, and I'm sure the panel would agree with me. The state has now made it very easy to form your own entity. You can go online with minimal effort and do it. The results are sometimes okay and sometimes comical. But the state has kind of allowed this to evolve this way. The sad thing is, people then think, well, the only thing I need to do is to file my either articles of incorporation or articles of organization, if it's an LLC, online, and I'm done. Well, no, that's just one little piece of the pie. So they are now lacking all the other things that they're going to need. For instance, now they either don't have share certificates or they don't have a member ledger if it's an LLC. And so when you talk to them and say, well, who owns what here? Who owns what percentage or how many shares of stock? And they will tell you, and then I say, prove it. They have nothing. They have nothing in writing. Well, sure enough, a year down the road, 2 years down the road, when things go south, now somebody's going to have a tough time proving what percentage of the business they own as they're splitting it up and going their separate ways. And it becomes an I said, he said, she said, we said, you said kind of a situation. Also, if they're going to go look for financing, the first thing their banker's going to ask for is, I want to see your articles, I want to see your operating agreement and your bylaws, I want to see your stock certificates or your member ledger, et cetera, et cetera, et cetera. They have nothing. So state for making it too easy for people to do this, but at some point in time, it's going to come back to bite them.
Yes.
Now that damn legislature. I just want to follow up on what Dave's saying. It's absolutely correct. But just sort of expound on that. Whenever in a business life, just as in an individual life, whenever you're about to have a major change, in our personal life, if you're about to have a major change, then maybe it's a good idea to see somebody like Allison and say, I need to look at my wills and trust, or that type of thing whenever you have a major change. The same thing is true with business. If you're going to have something that is out of the ordinary course of your business, the thing that I see as a common legal mistake is to do nothing or do it yourself type of thing. And yet it may have a major consequence to your business. So if you're, for example, adding a major new area to your business, and you're purchasing a whole different area, for example, the danger that you have is trying to do that on your own. You won't be able to see some of the issues that someone who's an experienced practitioner will run into. So say, for example, you're developing an LLC or a corporation. And like Dave mentioned, starting off a new entity is actually pretty easy. But particularly, for example, if you're going to have somebody who is with you in that entity, and it's not just yourself, that in addition, what Dave is saying, ought to raise red flags and at least say enough to say, I need to check with someone and see if I'm doing this right when you add someone into your business or someone who has control into your business. I have, in my years of practice, I have done things with they're called operating agreements or shareholders agreements or that type of thing. But I have also gotten in on the back end when that was not done. Situations, where there were otherwise close persons. I didn't think I needed to do that. I was in a relationship with my brother, for example, I've known for many years. We just thought we would get together. And where we can make really a lot of money, which is good for us, but not necessarily good for you, is when that stuff isn't done and you end up in longer protracted litigation.
Yeah, I think what you're saying here is that sometimes you don't want to be, penny wise and close down the road, because as a litigator, I can tell you, if you spent a little bit of money with David, keep everything tied up nice and neat, that's a lot less money you're going to spend with me fighting about it 5 years down the road, splitting up the company. So, yes.
Then as a follow-up, because I'm sure some of you out there are thinking, well, that really doesn't apply to me because I am a single owner of my business. I don't have other people, so therefore I can get away with this. Well, then the next most common mistake they made is, the whole reason they formed this entity to begin with was to protect themselves from personal liability for anything that might go wrong with their business. Well, then they begin violating all the rules unknowingly about how to operate this business in order to protect themselves from that liability exposure. And so one of the things, I spend an hour with them up front or longer, depending on how many questions they ask at the very beginning of the process, and I spend another hour to an hour and a half with them afterwards, going through all the things that they need to know and do. For instance, something as simple as, how do you sign your name? Okay? It needs to be obvious if you're signing a document that you're not signing it as Dave King, an individual, that you're signing it as Dave King, president of, to make it clear that you're not acting on behalf of yourself, but on behalf of your business. I could show you a lot of documents that you'd be hard-pressed to figure out, who's really the party here? Is it the individual or is it the entity? That's just one common thing that, you know, even if there's only one of you, there are still pitfalls out there, and it becomes an issue of how do you protect yourself. You know, you went to the trouble to form this entity. Well, now you've got to operate like you're really a legal entity and not cross that line such that it makes it easy for guys like Brian to come after you for personal liability for something that really, you know, was supposed to be a business transaction.
And I'm follow up on that. That's a real thing. I was involved in a lawsuit in my career, several $100,000 promissory note and guarantee, and the person who signed the guarantee signed it just their name, and it put as president of, you know, they had two companies, one that's borrowing money and one that's going to be the guarantor, so they thought. It ended up being a very expensive, protracted lawsuit about whether the person was liable on that guarantee personally or whether they had only signed on behalf of the company that they had intended to have be the guarantor. And I don't think they intended to do it, but they ended up settling for a fair amount of money and spending a bunch of money on attorneys. And so it's a real thing that can really happen. So I think also, like David said, following the corporate formalities too, because if you don't do that, you really can expose yourself to personal liability on behalf of the company.
Yeah, let me just mention one other thing. I did not mean to imply that if you were just going to do it yourself, you know, set up a corporation or LLC that's just you, not with somebody else, that you shouldn't go see someone like David, for example, and make sure you're protected, because some of those entities don't provide the protection that maybe you think they do. There's been a lot of changes in Florida law over the last several years, and some opinions by the courts where it may not provide the protection that you think it is, and you're just, you could end up just not only wasting your time and wasting your filing fee because it doesn't do what you think that it does, but also, probably more importantly, it doesn't protect you from the exposure that you're hoping that it does. Yeah.
I certainly don't want to monopolize the panel, but a couple of things about what you were just talking about, because I sit with a lot of clients where the what if becomes the what now, because they didn't plan and they didn't seek expertise where they needed to, and it's such an important area in how you form your business. The first part of my question is either for Charles and or Dave. Recently there were some changes in LLCs, and some legislation came down the pipes, and I tried to read the rules on that, and it was very long and very technical, so I put it in my to-do pile. So if you could maybe talk a little bit about what has changed on that. And then the second part of the question is for Dave and Allison. A lot of times you have a single member LLC or you have a 100% shareholder. What should those people put into place to protect themselves and their family if something happens to them and they're no longer able to manage the business, either for their spouse or for their beneficiaries? What should they do if they're 100% controlling and they're no longer in the picture? What happens then?
Well, one of the first things that you want to do that I urge all of my clients to do is, because I've seen the instance where we have the person starts the business, they're the president, secretary, treasurer, there's the sole director, and if something happens to them, you know, they're in an automobile accident, somehow they end up in the hospital, they're in a coma, whatever, you're going to bring that business to a screeching halt, because frequently, well, they're the only person with the authority to sign anything. Frequently, they're the only person who can sign checks. And I've had that exact thing happen. Of course, it only happened earlier in my career before I got smart, and I don't let people do that now. And I'll browbeat them until they, you know, make your wife a director, make her a vice president. Granted, maybe she's a school teacher and has no, you know, role in your business whatsoever. Make sure she can sign checks. You know, and that way, if something happens to you, even temporarily, there's somebody that can jump in there and pay payroll and do things to keep the business rolling until you're back on your feet.
And an important thing to remember is if you pass away, what's going to happen to the ownership that you have in that entity. So you need to plan ahead for that as well by doing your good estate plan. There are certain things that you can do within that entity to transfer that stock or ownership interest to your heirs without having to go through a probate proceeding, which can take a very long time
estate planning, Florida is one of the few states that has what we call the TOD, POD ability with corporate stock or membership interest in LLCs. TOD meaning transfer on death, POD means payable on death. In the past, only banks could utilize that, let's say, on your bank accounts. But now, Florida is one of the few states in the nation where you can actually do a TOD or POD for your corporate stock. And that way you can specify, if I die tomorrow, where's my stock going? And the neat thing is, now it's going to go automatically and immediately and without having to go through probate. And it's really kind of neat that we can do that. Thanks to the legislature, they just passed that. And what a great little estate planning tool. Saves probate expense and the time, and virtually immediately it can get transferred. If you want your stock to go to your wife, or if your children are active in the business, you want it to go to them, you can specify that. I mean, we're talking a 2-page document. This is not rocket science. It's something very easy to do, and I'm gradually converting all of my corporate LLC clients to this because it's so cost effective to do this, and it's simple, easy. You just gotta book them about it.
Yes, anything you can do to avoid probate is a good idea.
Yeah. Can you give a little more specifics to folks of what probate's about, and kind of how long does it take?
Probate is a court proceeding that when you pass away, if you have anything left in your individual name alone, without joint ownership to pass to the other owner, or without pay on death beneficiary designation to go directly to the people, those assets could be stuck in your individual name alone. And rather than just pulling out your will and signing those assets over to that heir, you have to go to the court and do a petition to the court to ask them to sign those assets over. And sometimes it can be a very long proceeding. It could take a year or more, depending on the amount of assets that you have. Also, you have to pay court fees to the court and attorney fees to the attorney. And if you can do it before you pass away by planning ahead, it makes it easier on your family, and it's much cheaper for them to deal with. Also, they don't have to go through that grief process while dealing with the probate as well.
And just as a brief follow-up, David talked a little bit about folks kind of doing themselves, creating LLCs and those types of things. What are your thoughts on sort of, the will offline? What are the risks of doing that?
It seems really easy to pull up a will and do it online, but there's a lot of laws that go into doing a will. There was recently a big Supreme Court case where somebody had one of those do-it-yourself wills, and the residuary clause did not encompass there was no residuary clause, which says that whatever I have left goes to these people. And there was enough assets that did not go to a certain person, the court, since there was no residuary clause. So it went all the way up to the Supreme Court, and they spent more money litigating that case than what was at stake. So it makes things very easy to go on LegalZoom and do your own documents, but much easier in the long run, and oftentimes cheaper just to go to an attorney and have it done by an attorney that can help you.
And if I could add to that, you may find this amazing or you may not, but if you're forming an entity, doesn't matter whether it's a corporation or an LLC, you do it through LegalZoom as an example, and you go through and do all of the things that you need to do, which are all of the same things I would be doing for you, you're actually going to pay 30 to 40% more if you get everything done than you would coming to me. Plus, you're going to get 2 hours of face-to-face with me so we can talk about all of these kind of things and get it right. But typically the folks that do the LegalZoom thing, they do step one and stop and don't do all the other things that they really need to do. So they think they've saved some money, but a year or two down the road they'll be able to see anything. But I recently discovered that. I was shocked at what LegalZoom charges, and for the entire package it's 30 to 40% more than what I charge, plus you get the FaceTime with LegalZoom.
And if you go and see an attorney in person, then you have that personal relationship with that attorney, and then they'll often tell you if there's any changes in the law. In 2011, we had a big change in the power of attorney law. So if you don't have that face-to-face and personal connection with an attorney, you may not hear about that law that's changed, and that's important to update your power of attorney now. So that's something else to keep in mind when you're using computer programs rather than a real attorney.
Yeah, you don't even know if they're enforceable in Florida, for instance, that type of thing. So it's something to be wary of. Charles?
I just wanted to follow up your question about LLCs and the new chapter. I authored that bill. So let me just tell you, just very, very briefly. I mean, there are dozens of by far it was the longest bill in the legislature that session when it passed. It just created a new chapter dealing with LLCs. But in a real brief nutshell, the new chapter is not designed to restrict, but provide greater alternatives to allow opportunities for greater competition. There is some technical things that were done to try to make it more uniform with what other states are doing. But there are a lot of things that increase its area of competition. You know, for example, allowing an LLC to be an LLC in Florida and an LLC in another country, for example. Some of them are like that. Some of them are simpler and so forth. The one thing, though, that it wasn't part of a change in the LLC bill that passed, I think it was last year, or the year, not last year, year before last, when the LLC bill had passed. This deals with single member LLCs. And this is what I was talking about, because you had mentioned something about that. Single member LLCs don't always afford the protection that a lot of people think that it does. There was a Supreme Court opinion that came out a few years ago that stripped a lot of the protections of LLCs that required the legislature to jump in and try to provide a fix. I sponsored that legislation as well, but I can tell you that legislation was what sometimes happens in government and politics. It becomes a compromise. And so the new single member LLCs provide some protection, but maybe not as much as you might otherwise intuitively think that it does. And that's why even in those instances, you know, again, if you're looking for a major change, a major change in life or a major change in business, you're going to set up a new business. You've got changes in your family. You want to have a change in your estate and how that's managed. That ought to trigger in your mind, I need to go see somebody who knows something about this area of law.
I know we talked a lot about LLCs, but is that the only corporate form that small businesses can use? Are there other options that people should take into account?
Well, no. In fact, I get this question 7 or 8 times a month. I'll have people call me and say, well, they'll say one of two things. Dave, should I be a corporation or should I be an LLC? Or most commonly, they will now call me and say, Dave, I'm starting a business and I want to be an LLC. And I go, oh, okay. And why have you already made that decision? Oh, because LLCs give you better liability protection. We call that the great layman's myth, because that's not necessarily true, number one. And I think what has perpetuated this myth amongst laymen is the name, limited liability protection. And that continues to perpetuate this myth. Actually, this is a very complex question, and the next thing I'm going to do after I talk to you and gather the basics, I'm going to call your CPA, somebody like Susan, and we're going to talk about it, because really there are not only liability issues involved here, there are tax issues and accounting issues. It's not there's not a simple one-size-fits-all answer here, even though laymen tend to think that, you know, they want to be an LLC because from, you know, last night when they were at their neighborhood bars, somebody next to them on the bar stool said, you should be an LLC. And that myth keeps going. But typically it involves the input of somebody like Susan, who's really good at doing this. Susan and I have a number of mutual clients, and we'll go through all those factors. We could be here another hour just discussing this one particular topic, and I'd be glad to talk to any of you afterwards about it. But I get this question 7 or 8 times a month, and we just have to work through all the factors, and from that we can then figure out, and I'll do it usually in conjunction with your CPA to make sure that we've got an an entity for you that is the best fit as far as liability protection, tax issues, and accounting issues. Right, Susan?
Right.
Yes. I have a question. A lot of it you've explained already, probably to Dave, would be, I also have a side business that I did professionally in the 70s as, a professional magician.
Mm-hmm.
I have recently thought about going ahead, getting back into it because I have all the equipment, and creating an LLC. Now, I was approached online by a company out of California, and I probably get a call a day from them, what am I doing? Am I still moving forward? They have some really low price to do all the paperwork, plus then you got the filing fees in the state. Would somebody in California really know what goes on in Florida as far as me being, and because I'm not doing it as a full-time profession, do I need to form an LLC just strictly to protect myself? Because when you get into the bigger shows, you stand a lot of, sometimes in the venues, something happens to you, you need to be protected. Which way would you rate to go?
Well, one of the roadblocks that you're going to run into if you continue to operate at a high professional level solely as an individual, there are some entities and some promoters who will not even hire you. Because if they hire you as an individual, they are now worried that they're going to have liability towards you as an employee, which becomes the worst of all worlds for them.
Right.
So they will only hire you if you are an entity. And that's not just the entertainment business, but that applies to a lot of businesses, whether it's construction or whatever. They only want to hire an entity, and that way they write a check to that entity, and they've then eliminated all those employee kind of issues that they would normally have. So, yes, you could operate as a sole proprietor, as we say, but you're going to limit the number of people who will hire you for your very excellent magic show that I've seen.
But as far as the,
Now, let's go back to your issue about these folks in California who say they can do this for you. Okay. I have enough trouble, because they will allege that they could form an entity in any of the 50 states.
Right.
I have enough trouble keeping up with Florida. To think that somebody could brag or advertise that they know how it works perfectly in all 50 states, ask yourself how practical. It's tough enough, right, folks? It's tough enough just to keep up with the constantly changing legal world in the state of Florida, let alone to keep up with all the changes that are constantly occurring in all 50 states.
Well, I need your card to make an appointment. It's basically what we're down to.
Any other questions? Charles, I wanted to kind of kick it to you for a minute and put you on the spot, put your legislator hat back on, just ask you from, a business perspective, what do you see as sort of some of the big issues for the next session, I guess, starting in March, right?
Yeah, regular session begins in March. We'll be in starting our committees in January. Legislators now that were elected in November are in the process of preparing and filing bills. And so we'll see really those different type of bills that are going to be filed over the next couple of months. Many of those we don't even know what they are. From a business perspective, the various barred entities will prepare legislation. Two of the ones that are, and you'll usually find a sponsor, a legislator sponsor. Two of the busiest, there's the business section, the real property probate trust law section, and sometimes we call them reptiles, because it's that way. I have talked to them. I anticipate, for example, with limited liability companies, they're going to try to, when you had such a lengthy, broad bill like passed 2-3 years ago, there's always going to be some hiccups. And so I anticipate someone will be filing a bill trying to clarify that area. And that's a major changing area. I know the business section is also looking at our corporate chapter. I don't know what items are being proposed, but I do know that that's a large area that they're looking at. In the real property probate trust law section, one of the major areas that I think will be looked at is the law involving guardianships, and that will be a major focus as well.
What can businesses do to kind of stay abreast of what's bubbling over there? And, you know, if they're interested in getting their voice heard, what would you recommend?
Well, I always recommend that if you want your voice heard, you need to talk to your legislator, whoever it is that is your representative, because that's the person they're going to listen to the most. I get all the time, I get these massive number of emails from some group or another. They're from all over the state. They're all the same. All the language is the same, and they're advocating this, that, or the other. And I and most of the other legislators don't pay attention so much on that because it's usually some interest group which is kind of driving it. What is probably more persuasive, if you have an interest in what's going on with an area of legislation, is to contact your representative yourself and put in your own language in an email or otherwise. I have an interest in this legislation that's coming up. Frequently you'll hear about, I mean, you can always go on the website, of course, the myfloridahouse.gov, for example, which is the website of the House, where they're listing all the bills, the pending bills, and so forth. But most of you are in a trade or industry or part of a group, and it's a good idea to ask them about some of the issues that are going on. For example, the chamber, the Florida Chamber, will be advocating various issues, and they usually have a good feel of what kind of bills affecting businesses are going to be happening, and communicating with them. But if you really want your voice heard, contact your own individual legislator yourself.
Yes.
I have a question for Allison, and one of the biggest things that a lot of people are challenged with today is caregiving. And probably all of us in this room know someone that's caring for an elderly parent. So what we're seeing a lot is that the parent is putting the adult child on their house, on their deed. They're putting them on the title of their car. And so my question is, that's a terrible tax move for one thing. But from an estate planning perspective, what are the implications there, and from liability? If something were to happen, if the elderly parent were driving in the car and that person's name is on the title, and for legal purposes, but can you talk about that a little bit, and what not to do and what to do?
Well, for estate planning purposes, that is one tactic that some people use to pass their assets to their heirs once they pass away. So if they're joint owners on a piece of property or on a car, once the other owner passes away, then the survivor is going to be the owner of that asset. So that's a good thing to do from an estate planning perspective. But from a liability perspective, that is not a good thing to do, because that way there's two owners on that asset. So if one of the owners gets in legal trouble or owes a debt to somebody, then they could attach that asset. So there could be a lien put on that asset. So it's not a good idea to do that from a liability perspective at all. Also from Medicaid planning, that's something that you want to avoid, and talk to an attorney before you do something like that. because that could be considered a transfer. So you could be disqualified from Medicaid benefits for a certain period of time.
What are some alternative ways to sort of accomplish the same thing from a safety point of view?
Well, you could set up a trust, so that would be a good way to pass the assets on without having to go to probate proceedings.
What's your opinion against life estate deeds to pass things on and avoid those liability issues?
Well, an enhanced life estate deed, it can be a good legal tool, but the problem with those is that there's not a lot of solid law on enhanced life estate deeds. Now, for those of you that don't know what that is, an enhanced life estate deed is where you reserve a life estate to yourself, but give yourself the right to sell the property, mortgage the property, rent the property out, do whatever you'd like to with the property during your lifetime. And then upon your death, it passes immediately to the other person that you put on the deed. Now, the law is not very concrete on that issue, because title companies say that as soon as you sign the deed, then that other person has an ownership in the property. So that would mean that somebody else could attach it immediately. But for Medicaid claim purposes and for probate purposes, the opinion is that the property does not transfer until death. So there's a disjoint there in the law, but it's a